In this short video today, I'll talk about deviation from voyage. So basically in today's video, I want to cover what is considered as deviation from voyage and when is deviation excused. This is a very important topic for mariners who are appearing for chief mates and masters written or oral examination in the topic of maritime law, because deviation is an important concept for you guys to understand, especially from also a practical application at sea. There will be times when you will have to deviate from the intended voyage, and you must understand the circumstances under which you will be protected by the maritime law, the marine insurance, and you will not land into a hot soup regarding the breakage of any kind of contractual agreement or charter party agreement that exists between your ship owners and the charterers. All right, so before I start, these are the two things we'll be covering. The two things that we'll be covering is what is considered as deviation and when is deviation excused. So what is considered deviation from voyage? So departing from the designated route is considered as deviation from voyage. So whether you are a liner trade or whether you are a tramp trade, the owners or the charterers will designate the next port of destination. They designate sometimes a whole passage, sometimes the next port of designation, and you are supposed to be on the intended track and route as per contractual obligations. If you deviate from that contracted route or the designated route, then it's considered to be as deviation. Usual route is departed from. So sometimes if you're not on a liner, if you're on a liner trade and you are supposed to be following a usual route, it could be a route in where you are following a South Asian ports or South African ports, or there could be a particular route that you're following as per liner vessels that container ships mostly do. Usual route departure from is also considered deviation. If the ship was required to proceed in geographical order and you don't do so, which leads to a wastage of fuel and owners will frown upon it, that is considered deviation as well. Ships must not deviate from the voyage without lawful excuse unless authorized by the terms of the contract or statute. If a ship deviates without lawful excuse, the insurers then are discharged from liability. They do not have to cover the vessel. And charterers may also sue for damages or cancellation of contract. The owners will have to suffer, and if the owners suffer, I'm sure that they will not like to keep you on the ship as well. You will get rid of the job as well. So the clause of the policy shall stipulate precisely for what purpose the vessel is allowed to deviate. So only as per the charter party or the owner's contractual agreement, you have to understand what is considered deviation. Otherwise, if the insurers discharge your vessel from liability and tomorrow your vessel runs into any trouble, the owners then start to bear the expenses, and the charters will also sue for damage to cargo or late cargo. The shippers of the cargo will also sue, and the owners will not be happy. If the owners are not happy, they are your employers most of the times, and you will lose your job as well. So most of the times, as per charter party agreement, when is deviation excused? So deviation is excused when authorized firstly by special terms such as towage or salvage. If in your charter party agreement it is allowed for you to proceed towards towage, that is assisting other vessels by towing them, or salvage, that is rescuing the other vessels in peril, where you can be compensated by a salvage award, then that is not considered deviation. Circumstances beyond your control or the master's control or the officer's control, such as a tropical revolving storm or a bad weather, and you are trying to seek refuge from bad weather or ice, or because of which you have slowed down the vessel or you have deviated to protect your vessel from an oncoming hurricane, necessary for the safety of ship or cargo. So like I said before, if you have deviated from the voyage or you have altered course in such an extent that it delays your next port of arrival, to avoid a hurricane or a tropical revolving storm, or you're stopped by, like the example I like to give is I used to come from Japan and go towards Hong Kong, and often on the way we used to have tropical revolving storms coming in from Philippines. So to protect ourselves, we sometimes had to seek port of refuge, or rather seek shelter, sometimes in Anchorage or behind Taiwan. We would let the storm pass off and go north of us, and then we would come out of Taiwan again and then proceed on our usual intended track. So we used to deviate sometimes from the voyage, but of course we had the owner's permission to do so because we were doing it for the necessary safety of ship and cargo. So if you can justify that you did all you can, and no amount of alteration or reducing of speed or speeding up of the ship will avoid any kind of damage, then of course it is justifiable. If you deviate in order to comply with a warranty, so for example, for carrying out any kind of seaworthiness test, or ship's hole, if the ship's hull develops a hole, or if your certificates have expired and you need to get the ship certificates done, which should actually be done, ideally be done much before time, but if it's required from a legal perspective as well, then you may be allowed if you have taken all the precautions, and maybe the owners were unable to arrange for a surveyor in the last port and you have to now deviate to get a certificate, then also it is justifiable. For the purpose of saving human life or assisting a ship in distress, of course, it is by law required by most of the flag states, most of the states, that if you find any distress vessel that you can proceed to for distress rescue or for rescuing a person at sea or abandoned people at sea, then of course you are excused for deviation. If it is required for obtaining medical aid, somebody is so seriously injured on the ship that you need to seek medical aid immediately, or you need to land them ashore for them to help get medical assistance, then that is not considered deviation as well. When caused by criminal acts or misconduct, an example or severe example I can give you is sometimes if a master has been injured or master has been killed by the ship's crew, or and you need immediate relief. Now I'm talking about extreme situations here, or somebody has passed away, and I'm talking about criminal acts here, so that's why I'm talking about people being killed or murdered, and then you have to relieve them, you have to replace the master, you have to maintain the safe manning certificate, and for that if you deviate the ship, then that's fine as well. Finally, when the cause excusing the deviation ceases, the ship must resume her course and proceed with her voyage as soon as practicable. Alright, so as soon as you are ready to do so, please do so. Otherwise, if you can't justify why you delayed, caused further delay, then the same complications between the charterers and the owners and the shippers of the cargo, all that will take place. The insurers will also wash their hands away from insuring the vessel, and if your vessel is not insured, if anything happens, then the owners have to bear the responsibility and the expenses, which they will really frown upon, and that will put your job in trouble as well. All right, so I hope you guys understood what is deviation. In a separate video I've discussed port of refuge, so make sure you watch both these videos to understand what is considered as seeking port of refuge, and what circumstances you can do so, and action taken to be by the master. And this video is very useful for you guys to understand what is deviation and when is deviation considered and when is deviation excused and covered by the insurers. I'll see you soon with my next video, guys. All the best with your studies. Bye for now.